specializes in assisting businesses navigate complex employment law issues and avoid unnecessary litigation. She's a member of the Los Angeles County Bar Association and the Pasadena Bar Association, and she received her JD from Pepperdine University School of Law. So without further ado, Roxana, how are you doing today?
I'm doing fine. Thank you so much, Scott, and good morning to everyone. I love this presentation because I chose 5 questions that we get most of the time for our clients, which tends to indicate that these are the questions that most people have. So hopefully this will be helpful to the people on the line. So let's start with the first one, and this is one of my favorite ones. Can I classify an employee as an independent contractor? Well, the question itself, an independent contractor is not an employee. So an individual cannot be both an independent contractor and an employee. It has to be one or the other. An employee is somebody who gets compensation, and at the end of the year will receive a W-2 form from the employer. That means that this individual is on the employer's or the company's payroll. An independent contractor is not on the company's payroll and will get or receive a Form 1099 at the end of the year. The reason why this option seems appealing to many employers is that employment laws do not apply to an independent contractor, which means that the individual does not have to get meal periods, rest periods, get paid overtime, or comply with a minimum wage. So all those requirements do not apply to an independent contractor. However, under California law, a person performing work for another will be presumed to be an employee. So what this means is that to retain the services of somebody as an independent contractor, we need to make sure that that person falls under the category or meets the requirements of an independent contractor, which you'll see are not easy to meet most of the time. So who is an independent contractor? An independent contractor is a person who provides services to another person for a specific amount of compensation for a specific result, and the person who is retaining those services has very limited control as to how those services are provided, and primarily has control over the result of the services. So think of somebody who gets hired to remodel a kitchen. You're gonna hire that person for a specific project. That person probably gave you a quota. You're going to pay him a specific amount, $30,000, $35,000, whatever that might be. And you who has hired the person doesn't really have control on how he is going to accomplish the job, but you do have control only of the outcome of the job. That is the definition of an independent contractor. On the other hand, an employer who has an employee has the right to control the manner and the means of accomplishing the result desired. So this is kind of like the 2 definitions, legal definitions of an employer and independent contractor. So how do we go about making the analysis when one of my clients calls me and says, can I hire this person as an independent contractor? Well, it's a very detailed analysis, and it's really a case-by-case analysis. There are some guidelines out there, and one of them is the IRS has a list of 20 factors that they will consider in order to determine whether somebody is an independent contractor or an employee. Now, those factors focus primarily on control. How much control the employer exerts over the worker's behavior and work results, meaning who controls training, where and what time the person works, schedules, the equipment that the person uses. Second, how much control does the employer have over finances? Does the employer have primary control over the person's profit or loss? The idea here is that if somebody is an independent contractor and they have control of their own time, they have control of whether or not they make a profit or they lose money on the project. Finally, what is the relationship between the parties? Does the worker receive benefits? Is it a long-term relationship, or is it a project that's going to be completed in 1 week? Is there an agreement in place? Now, the next 2 pages I have given you, the next 2 slides, the 20 factors. We're not going to go through all of them, but you will see that those 20 factors really analyzes how much control the employer has, or you as the employer would have over that person. So the checklist is provided to determine who has the right of control. And it's not so much the right to control, not actually controlling the job, but who has the right to control. That's how they determine independent contractor over employee. I always say that if there's a gray area there, if it's not clear whether somebody is an independent contractor or an employee, then you're better off classifying that person as an employee. We'll see in a little bit that the consequences of misclassifying an individual as an independent contractor can be significant. So then the next question that I usually get from the clients is, well, what if we have an agreement? What if the individual acknowledges in writing that he is an independent contractor? Wouldn't that protect me, the principal? And the answer is, it depends. The agreement is only one factor to be considered out of those 20 factors that we have in the prior slides. And it's not the most important one. The most important one is the right to control the means and the manner that the job is being performed. So it's really a balancing act and depends on all the specific circumstances, and sometimes that analysis might change based on the specific industry. As I said before, the consequences of mischaracterizing an individual as an independent contractor can be significant, because if you pay somebody let's say a flat fee or even an hourly fee for the work that they have performed, the law would apply that payment only to the first 40 hours of work in a week or the first 8 hours in a day, meaning that if the person worked more than 8 or more than 40, then he will be owed all the overtime that person will be entitled to. Also, since most likely you did not keep track of meal and rest periods, that person will be able to recover for having missed the meal and rest periods. Record-keeping violations. The law is very strict about the type of documents that must be maintained for an employee, especially a non-exempt employee. If we hire somebody as an independent contractor, we're not going to have those records, and then we will have penalties that come along with a failure to maintain the proper documentation. Penalties for unpaid wages. The list can go on and on concerning the wages, violations, penalties that that person will be entitled to recover. And remember that in California, an individual can recover back to 4 years of wages and penalties if he was not properly compensated. Now, in addition to all the labor code violations that you may have, of course, there's also potential tax law violations, workers' compensation violation, immigration, wrongful termination, FEHA, FMLA, CFRA, all those laws that apply to an employee, there could be potential violations of those laws as well. And finally, the law also provides for penalties up to $25,000 for the intentional misclassification of an employee. So again, if you are in doubt whether somebody is an independent contractor or not, I will highly suggest that you hire that person as an employee. And just remember that it's very difficult to meet those requirements. Where I see that most of the time with my clients are with salespeople. People feel, well, you know, they're working outside of the workplace, they're able to work their own hours, and there's no minimum requirement of hours or quotas. Even in those situations, it's very difficult to have that person meet the requirements of an independent contractor. Okay, moving along, the next question that I get most of the time is, am I liable to an employee who chooses not to take a meal period? Very often I have clients who run restaurants, and they say, look, they don't want to take their meal period. They want to continue working because most of the compensation comes from tips. Well, the best way to answer this question is to first analyze what is the requirement under the law. And this is going to apply primarily for California. I understand there's some of you out there who are not in California, outside of California. The law there might be different. So this is primarily applicable to California employers. And the California law requires that an employee be provided with no less than 30-minute meal period when the employee is working more than 5 hours. What this means is that the employee must start their meal period before the end of the 5th hour. If somebody starts working at 8 o'clock in the morning, they have to start their meal period before 1 o'clock, meaning 12:55, 12:52, 12:45, 12:30, any time as long as the meal period begins before 1 o'clock. Now, the requirement is that the employee be relieved of all duty and must be free to leave the premises, and both requirements are important. If the employee is not relieved of all duties, the meal period must be considered on-duty meal period. Now, this is only permitted when the nature of the work prevents an employee from being relieved of all duty. There must be a written agreement if somebody wants to take advantage of the on-duty meal period, and that agreement must also explicitly state that the employee has the right to revoke the agreement. Now, I generally do not recommend that employers use on-duty meal periods because very often they're found not to be valid. The reason being that if there's any way that employee can be relieved for those 30 minutes, then the law expects the employer to relieve the employee. The cases that I've seen where an on-duty meal period is appropriate will be something like a home for disabled patients or elderly where there's only one caretaker and there's nobody who can relieve that employee for 30 minutes. And on top of that, there's a requirement that that patient or that client have constant attention or care. So very few instances where an on-duty meal period apply. Otherwise, if there's any way that an employer can relieve that employee, then the employer should, and there's an expectation that they should do that. This is a case where an employer requires employees to remain on the premises, even though they were relieved of all duties. The law said no, both requirements must be met. They have to be relieved from duties, and they have to be able to leave the premises. Otherwise, the employer will be responsible for that 1 hour of penalty. So in summary, how do we satisfy our obligation concerning meal periods? Okay. There was a recent case a few years ago, we say recent, but maybe 4 or 5 years ago, the Brinker case that said, wait a minute, the employer is required to relieve the employee of all duties, is required to allow them to leave the premises, but the employer does not have to be the police of the meal period, meaning that if the employee chooses to continue working, even though he's been allowed the opportunity to stop all duties and to leave the premises, then the employer would not be responsible. Okay, but having said that, the court still said you must relieve them from all duty. You have to relinquish control over their activities, permit a reasonable opportunity to take those 30 minutes, and also the employer cannot impede or discourage them from taking the meal period. Meaning, if there's some kind of bonus or some kind of offer that is offered to the employee to work through the meal period, then the law will determine, well, no, that was really not a reasonable opportunity to take the meal period. So, if the employee is relieved of all duty and he's free to leave the premises and there's no discouragement or coercion from the employee, but the employee freely chooses not to comply, then the employer will not be liable. Okay, so that's how we get to this answer. No, you will not be liable as long as you meet all the requirements under the law. If the employer knows or has reason to know the employee is performing work, then the employee must be compensated. So in summary, what I generally tell my clients, to protect yourself, you should continue to be the police of the meal period. Ensure that all your employees take their 30 minutes, meaning the full 30 minutes, not 28, not 29 minutes, because then you will have a technical violation. Make sure they take it before the end of the 5th hour. Make sure they're able to leave their premises. Now, for whatever reason that doesn't take place, the law does allow for a self-imposed penalty. And I had that here on the prior slide at the bottom. If because of work requirements of whatever other reason, the employee is not able to comply with, take the 30-minute before the end of the 5th period, or takes a short meal period, then the employer can pay an additional hour of pay as a self-employed penalty, and then the violation has been corrected, which I recommend that employers do. Now, if you have an employee who's constantly violating your meal period policy, you should pay them the additional hour of pay, but you have the option to cancel that employee, and that's what I generally recommend. So we don't take the decision, well, you didn't take the meal period and it was your choice, so we're not going to pay you, but you counsel the employee and make them understand that they have to comply with the law. Now, so just to summarize, the way that I suggest my clients to address this issue, every employer should do self-audits on a regular basis, whether it's weekly, payroll period, maybe a quarter, depending on the size of your workforce. That somebody should be conducting self-audits. You review the timesheets and you realize that somebody took either a late meal period, or maybe they did not take a full 30-minute meal period, or they didn't take one at all. The way to address that is to contact the employee and to ask them, what happened on this day? It might be that the employee said, I forgot to punch out for my meal period, or I wanted to wait for a friend to have lunch with him, and that's why I took it late. If any of those answers clearly indicates that it was the employee's choice not to take a proper meal period, then you do not have to pay them the hour penalty. But you do want something in writing from the employee acknowledging that it was his or her choice. If the employee's response is, well, I couldn't take the meal period on time because there was too much work, or because my supervisor told me to finish a project, then in that case, we're going to pay that employee the 1 hour of penalty in order to correct the violation. A couple little breaks for the employer. If you have an employee who works no more than 6 hours, then that employee can waive their meal period. If an employee works more than 10 hours, but not more than 12, the employee can choose to waive the second meal period, but only if the first period was not waived. So 2 exceptions here. If the employee works no more than 6 hours, he can waive the 30 minutes completely. If the employee works more than 10 hours but less than 12, the employee can choose to waive the second meal period, but only if they took the first one. Now, there's no requirement that this be in writing. However, there has to be mutual consent. So the only way to prove mutual consent is to have this policy in writing. I generally suggest that if you can benefit from these situations, that you have the employees sign these waivers when they're hired. You don't need to have them sign every time they're waiving their meal period. You can have one in the file, and that is sufficient. So to take advantage of this, you need to have something in writing. And like I said before, make sure that you conduct regular self-audits to protect yourself. And the third item here I always like to remind employers is training of management. At the end, compliance with meal and rest periods, it's really under the control of direct management, and they should know what is required of the law so they can help you enforce the law. Third question that I get very often is, well, can I terminate an employee after the employee has exhausted FMLA leave? Now, I have several slides concerning this topic here. We're not going to go through all of them, but I figure that if you have it handy, you can always go back and use it as a reference. So for some people are not familiar with Family and Medical Leave Act. That is a federal law that applies to all employers in the United States. Pretty much any employer who has more than 50 employees. It does not apply to employers who have less than 50 employees. So any employer who has more than 50 employees must provide up to 12 weeks of unpaid job-protected leave to an eligible employee, meaning that if somebody takes FMLA leave, you need to hold that position open for that employee for 12 weeks. Okay? Now, who's an eligible employee? It's going to be an employee who has been employed for at least 12 months and has worked at least 1,250 hours during that 12-month period. Okay? If the employee does not meet those two requirements, then he's not entitled to get those 12 weeks of unpaid job protected leave. The FMLA like I said, provides up to 12 weeks of unpaid job protected when an employee has a serious health condition that makes the employee unable to perform his job, when the employee is incapacitated due to pregnancy, when the employee has to care for the birth of a child or adoption, or when the employee has to take care of the employee's spouse, son, daughter, or parent with a serious health condition. Now, under California law, for those of you who are lucky enough to be in California, we also have CFRA. The CFRA mirrors the FMLA, and they kind of run concurrently. So you don't need to, most of the time, you do not need to break them apart unless we're dealing with somebody who's pregnant, because under California law, we have our own pregnancy disability leave. Another difference between CFRA and the FMLA is that CFRA includes registered domestic partners, and like I said before, we have our own pregnancy disability leave. That pregnancy disability leave in California is pretty generous. It applies to employers who have more than 5 employees, and it applies to full-time or part-time employees. That employee who is disabled by pregnancy, and this is something key to remember, the employee has to be disabled by pregnancy, not just because they're pregnant and they're entitled to take this time off. But under California law, a disabled pregnant employee is entitled to take up to 4 months of leave, or what the law has described as being 17 1/3 weeks. It can be taken before and after the birth. In California, the employer will be entitled to both pregnancy disability leave and CFRA to take care or to bond with the baby, which means that in California, an employee can be out 4 months for the pregnancy and an additional 3 months under the CFRA for a total of 7 months. Okay, so going back to the question, the original question. So if I have provided an employee FMLA leave for 12 weeks, either 12 weeks under FEHA, under FMLA and CFRA, or even the 7 months after somebody took a combination of pregnancy disability leave and CFRA. Can I terminate that employee if they do not return to work after that job protected leave that they have taken? And the answer is generally no. The reason being that FMLA, CFRA, and pregnancy disability provides a job protected leave. After that has expired, we still cannot terminate an employee because now they are under the protection of the FEHA or the ADA. FEHA is a state law, and the ADA is a federal law. So these laws prohibit discrimination, harassment, and retaliation on the basis of a disability. They also require that the employer provide a reasonable accommodation to any employee who's disabled. So the FEHA and the ADA do not provide job security, but they do require that you provide a reasonable accommodation. So that reasonable accommodation might be an additional leave of absence. So whenever an employee calls me and says, okay, the 12 weeks have expired, or the 4 and 3 months of the pregnancy and the CFRA have expired, and they're not ready to come back to work yet. Can I terminate them now? The answer is no, because now you need to start the process under the FEHA and the ADA. You need to engage in the interactive process with that employee to determine whether an additional leave of absence would be applicable under the situations. Now, one of the questions that I get all the time is, well, how long does that reasonable accommodation have to be? Or, how much more leave do I need to give that employee? And the answer is depends, because what the law provides is that the reasonable accommodation be reasonable. So what is reasonable is all going to depend on the specific circumstances. It might be that it's 3 months of additional leave. It might be that it's 6 months of additional leave, a year. It really depends. I generally see cases where 6 months seems to be reasonable. But again, that's going to depend on the specific circumstance of the case. And of course, it's also assuming that that employee actually brought you a note from the doctor, something that the doctor says this person continues to be disabled and it needs to be off work. Okay. Now, generally, what the doctors will do is they'll send you a note that says, well, the employee needs an additional 4 weeks or an additional 60 days or whatever that might be. As long as the employee brings you those doctor's certifications saying that they need additional time, then you're going to provide them that additional leave as a reasonable accommodation. If you were to get a note from the doctor that says, employee continues to be disabled and we do not know when he is going to be able to return to work, then you do not have an obligation to provide the leave of absence, because an indefinite leave of absence is not required as a reasonable accommodation. And that's the reason why you see most doctors give you 4 weeks, 60 days, 90 days, 2 weeks until the employee gets re-examined again. Okay, let's see where we are here. Okay, so an accommodation, like I said, it can be a leave of absence, but it can also be other steps that need to be taken: job restructuring, part-time work, modified work, reassignment to a vacant position, and there's the one that we're discussing today, a temporary leave of absence. There's no requirement to provide an indefinite leave of absence. Equipment or special devices, all those can be a reasonable accommodation. But the key here is that an additional leave of absence will also be an accommodation. Therefore, we're not going to terminate an employee when they have exhausted their FMLA, their CFRA, or their pregnancy disability leave. The only basis to deny an employee a leave of absence as a reasonable accommodation would be if the employer can show that that leave of absence will cause undue hardship. Undue hardship is difficult to prove, so I always caution employers about denying somebody a leave because of undue hardship. There's been a couple of cases at the federal level recently that have provided a little more information about what is a reasonable amount of time as a reasonable accommodation. And one of them said that 4 weeks was sufficient, and another one said about 3 months. But I still generally, especially under California law, I would use the 6-month time period at least as an additional accommodation for a disabled employee. Okay, so we talked a little bit under the interactive process. I can give you a little more guidelines on how to engage with the employer in the interactive process. This is where I see a lot of the lawsuits concerning disability, is because of the employer's failure to engage in the interactive process, or more importantly, to document that interactive process. They would tell me, oh yes, I did talk to them on the phone, I did ask them what they could do, what they could not do, but there's no documentation to prove that they engage in that interactive process. So it's important to remember that it has to be timely, it has to be in good faith. If possible, meet the employee in person to discuss what the employee believes they need in order to be able to perform the essential duties of their position. If you have forms, make sure you comply with your own form system. It's important to have a job description. If you're going to engage in the interactive process, a job description can be very, very helpful. Okay. Another thing to remember about the interactive process is that it's an ongoing process. It's not just one meeting, one conversation with the employee. If the employee continues to be off work for 2-3 months, it's important to contact that employee again and find out what is going on. Make sure that you're getting your doctor's note when the doctor's note has expired. Okay, so moving on. Can I discipline an employee who criticizes management on social media? I've seen in the last year a significant increase in from the National Labor Relations Board. That is the federal agency that oversees the National Labor Relations Act. Just as a start, what does the National Labor Relations Act provide? Section 7 of the Act guarantees employees the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. As well as the employees have the right to refrain from any or all such activities. So you must be thinking, well, this applies to workplaces where there's a union involved. Well, not really. The Act, the National Labor Relations Act, applies to all employers, the ones who have unions and the ones who don't have unions. So this right applies to everybody, every single employer in the United States. And what that law pretty much says is employees have the right to help each other by sharing information, signing petitions, and seeking to improve wages and working conditions. That means that any communication among employees concerning wages, benefits, working conditions are protected, and an employer cannot prohibit employees from engaging in those type of activities. Again, this applies even if your workforce does not belong to a union. So in recent cases, what we have seen is that the board has determined that this protection applies to communications among employees via email. If the employer allows employees to use the email system during the non-working time, and the employer gives them access to the email system for business communication, that means the employees can use the email system to communicate with each other concerning their working conditions or pay or benefits. And that means that employers cannot cancel those employees for engaging in those communications. So there were two recent cases concerning social media, because all the cases seem to somehow bring social media into the new fact scenarios. But in this one, there was an employee who posted a pretty offensive posting on Facebook, and you can see there at the bottom of the last bullet point. And the board found that the Facebook post was a lawful expression of the employee's feeling about the company and his supervisor, especially when the comment appeared during the run-up to an NLRB supervised union election, which means that the employees were trying to belong to a union during this period of time. The board said even though the Facebook post was vulgar and inappropriate, it was not so egregious as to exceed the Act's protection. So as you can see, this is pretty broad. So as you can see, the employees, based on these board cases, have a legally protected right to criticize their employer and urge workers to think the same way about the company. The other case that we had, although this is still the same case, the court reasoned Facebook post addressed workplace concerns regarding treatment of employee in an upcoming union election. The employer had a past tolerance of profanity in the workplace. Activity did not occur in the workplace. An employer removed the post from the Facebook shortly after learning that the post was publicly accessible. The other recent case that addressed employees criticizing management on social media or a public medium was a security officer who called into a talk radio show to criticize his employer, which contracts with TSA, and to advocate that TSA operations not be contracted out to private companies like his employer. The board determined that the call was legally protected because the call was a logical outgrowth of the employees' discussions of their common complaints. So what do we take away from these cases? Business owners must be very careful when they choose to discipline or terminate employees who have publicly criticized the company if the criticism involves or relates to workplace conditions. This applies to both union and non-union employers. Like I said, recently we have seen an increase on these claims being filed with the NRB, where the employer has to defend. And a misconception that many employers have is that employers can prohibit employees from discussing their pay or their compensation, their salaries, their hourly rate. And the answer to that is no, an employer cannot prohibit that. You can have a policy that discourages employees from communicating or disclosing their compensation, but even that, under the current environment, will be risky. So, in summary, employees have the right to discuss with other employees their wages, their benefits, and their working conditions, which includes treatment from management and any criticism concerning supervisors and management, whether they do it face-to-face, whether they do it through email, whether they do it on social media. The employer does not have the right to prevent that type of conduct. The other question that I get very often is, can I mail an employee's final paycheck? Now, this is pretty basic, but the way that this happens sometimes is that an employee, let's say, abandons his job and doesn't show up to work, and the employer will call or send a letter saying you have failed to show up to work on 3 consecutive days, therefore we are assuming that you have abandoned your job, you're no longer an employee. And the desire at that point is to include a final paycheck with that letter to the employee. Well, that would not be in compliance with the law. So let's review briefly what are the requirements. If the employer terminates an employee, the final paycheck is due immediately at the time of termination. We do not wait until the day that payroll, payday, or the day that payroll can get to us the final paycheck. Final paycheck is due immediately at the time that the employee is being terminated. Okay. Now, if the employee resigns and gives you at least 72 hours notice, then again the final paycheck is going to be due at the time of separation. If the employee resigns but doesn't give you at least 72 hours of notice, then you have 72 hours to provide the final paycheck to the employee. Now the question becomes, how do you provide the final paycheck to the employee? The law does say that the final paycheck must be made available to the employee at the place where the employee worked. So generally what you do, you will tell the employee who resigned without giving you 72 hours notice, your final paycheck will be ready on this day at this time. Please come pick it up then. Only if the employee says to you, can you please mail me my check, can you mail the employee the check. I would like to have something in writing concerning that, whether it's an email or something written, but something in writing that shows that the employee requested that the final paycheck be sent to that employee. So how do we address the issue of the employee who abandons his job and you have not been able to give him the final paycheck? What you do when you send a letter, you tell the employee, we have prepared your final paycheck and it's here at the office. Please let us, you can come pick it up at any time, or let us know if you want us to mail it to you. Then if the employee gets back to you and says, yes, please mail me my check, you can go ahead and check the mail, mail the check. Another question that I get very often, well, what happens if they never come to pick up the check? You just keep it there. You keep it in the file or you keep a copy. I know the Labor Commissioner in California has some program where employers can send on cash checks or checks that have not been picked up and goes into an unclaimed fund. That's another option. or you can just keep the check in your file to show the date that it was prepared and that you did comply with the requirement that be prepared within 72 hours, or at the time that you send a letter to the employee letting them know that you were terminated their employment because they abandoned their job. Something else to remember about final paychecks is that final paycheck must include all hours worked, but it also must include any accrued vacation. Accrued vacation is considered to be wages. So when the law says that all wages are due at the time of termination, that includes any accrued vacation. Just as a refresher, under California law, there's no requirement that an employer provide vacation, but if you do provide vacation, then you need to comply with the requirements under the law, and it's extremely a good idea to have a written policy concerning vacation if you're going to provide vacation, especially if you want to have a cap. Then the courts have also said that if the employee did not take a proper meal or rest period and they're owed a penalty for not having provided a proper meal period, that penalty is also considered a wage and needs to be paid at with the final paycheck. So it's a good idea when you terminate somebody to go back and review the employee's file to make sure that that person has been paid all wages that are due, that there's no potential overtime owed to the employee, that there's no meal or rest period penalties that might be owed to that employee, to make sure that you include everything on that final paycheck, meaning wages, overtime, any accrued vacation, and any unpaid meal rest period penalties. Those are all considered wages and should be part of the final paycheck. If you fail to give an employee a final paycheck as required under the law, then the employer will be responsible for what we call 203 penalties, which are up to 30 calendar days after the termination or the separation of penalties. And not the equivalent of 1 month of pay, but it's actually 30 calendar days. Whatever the employee was earning on a daily basis, that amount gets multiplied by 30, and that would be the calculation of a 203 penalty that is owed to the employee. I just went to a labor commissioner hearing a couple of days ago where the employee claimed that he was not paid 1 week of vacation at the time that he was terminated, and that was the equivalent of about $3,500. The employer earned about $47 an hour. But the 2 or 3 penalties for not having paid that 1 week vacation was about $12,000. So it's very important that we do that analysis when we are going to terminate somebody to make sure that final paycheck includes all